Hey guys, how are you today? We're starting off this new year. We're approaching February, and on February 1st, we got some new contracts coming up, and I'm going to hit over a few of those. And what we're going to do this year, because of the internet issues and Facebook, getting on Facebook, we're going to do a little more of filming and then having her editing, and then we're going to be posting things to MHG Life, and that gives you guys the opportunity to go and view it. There'll be things you can share with your customers at times, because we're setting up a little studio over in that corner. Today though, I want to go over the contract. Adopted changes for all contracts, and you're going to see some great things going on. They simplified a lot of things. I really enjoy some of this. But the term escrow agent is capitalized throughout the contract. And you can go to TREC and they'll tell you the adopted changes, but I'm going to go over them real quick. Paragraph, the term escrow agent is capitalized throughout the contract. Paragraph 3 is amended to add the definition of the cash portion of a sales price. Like that need to be defined, but apparently it did, okay? A new required notice section is added to paragraph 6, which provides a location where MUD, PID, and other similar notices have been given and are attached to the contract. They can be listed there. Paragraph 7F is revised to require that the seller provide the buyer with copies of documentation from the repair person that shows both the scope of the work and the payment for the work has been completed. Transfer at seller's expense any transferable warranties at closing, and that is 7F, and that's a big thing right there. We got a lot of these guys, well, I can do it myself, and they are able to do it themselves if both parties agree, and if it's simple. I mean, if you're just replacing like a fascia on a light socket or something like that, I don't have a problem with doing that, but other than that, I have to be licensed contractors. Okay, 7H is amended to replace the term residential service company with the terminology used by the Texas Department of Licensing and Regulation, September 21st, and that regulates residential service companies. Okay, that's the home warranty companies, and so we do, as you know, we don't take any money from anybody out there, and so you get a lot of these home warranty companies that aren't in our area, so you want to be real careful when we're making recommendations to our buyers or even our sellers on the home warranty companies. We do have some very good ones that do have reps here in the area, and we don't take money from any of them. So we rate home warranty companies, lenders, inspectors by how they service the customer, not what they pay us. And that's, no conflict of interest there. So that makes that pretty good. Paragraph 9B, parentheses 3, is amended to add the transfer of any warranties to correspond with the change in paragraph 7F. Paragraph 9B, section 5, provides that private transfer fees will be the obligation of the seller unless otherwise provided in the contract, and the transfer fees assessed by the Property Owners Association are governed by the subject to mandatory membership in the Property Owners Association. A similar sentence is added to the condominium contract. So as long as you know that, we got that. Paragraph 11 is also going to be amended to further clarify the intent of the paragraph by replacing the terms factual statements with business details and informational items. I like this, okay? Which is now defined and adding the real estate brokers cannot practice law and prohibited from adding to, deleting, or modifying the contract unless drafted by a party to the contract or the party's attorney. Lines have also been inserted into this blank, and this is the special provisions. And here's the situation. They really don't want us to use special provisions, but they have to have it in there. And the reason they have it in there is if you can add things, and it says this in there, you can add things like the address was too long, okay? The name of the buyer or the seller was too long. That's where you go and correct that. You do not amend the contract or change the contract in that, okay? We don't do that here, we'll cover that. Now, when you have an agent that tells you, well, I can't take a contract that's got anything written in special provisions, absolutely wrong. TREC is defined clearly. Now, what can we put in there? Well, as clear as they do. And so I'm the one that tells you how to write a contract. All contracts have to be presented. So if we write it and you put in there like it's a big long name and it won't fit, and you drop down, you put a special provision, buyer is named so-and-so and so-and-so, corporations divided by LLC, whatever you want to write in there. If you do that, that's completely legal. But here's the deal. They can't tell you how to fill out a contract. We're the ones that advise you how to fill out a contract, and I have a lot of good input on this, okay? I have Ashley Rawls, who's a broker, okay? She helps me quite a bit, my lovely wife, okay? I have Renee, I have Linda, I have Heidi. We have a lot of people in here that do a lot of deals that help us quite a bit with figuring this out. I also have some consultants and some attorneys and things like that that give us advice on what to do. We want to be very careful when we put in there, but I mean, the address is too long, lot blot's too long, names are too long. That's the perfect place to put them in special provisions, and they're addressing that. Okay. Paragraph 13 is amended to clarify the amounts of what will be prorated through the closing date. 18B is amended to add that if no closing occurs, the escrow agent may require a written release of liability before releasing the earnest money. And they may require. That says may not. If it is a clear-cut situation where one party or the other gets it, they may look at the contract and go, you know what? We don't need a signed release earnest money. This guy is being an idiot. We're going to release it and send it on its way. The great thing about that is if they do go ahead and decide to release it, the seller, the buyer, or whoever signs a release of earnest money, if they don't have to sign a release of earnest money, if the title company clearly states that it's the buyers or it's the sellers, then they don't sign that form that says at the top, the release of earnest money says you can't sue them if things go wrong by taking the earnest money. It's a great idea, and that's May, and that kind of protects the title company because we've had some sellers out there, no matter what, they think the earnest money is theirs, and that's not. The contract stipulates some things that help the buyer. Paragraph 21 is amended to add the line for a copy of the buyers and sellers agents respectively. Okay, you got changes to all kinds of farm and ranch contracts and all kinds of other stuff. We're going to go over that as we go. I want you guys to, be very careful of what you're doing out there. We're going to make this video. It's going to be posted up there, and we're going to go from there. I just hit the high spots, and of course, I was talking pretty fast, and I'm sorry about that. But what we're going to do is the videos we're going to be putting up now, you're going to see more and more what I'm talking about. Carly is going to take my notes, okay, that I'm using on these, and she's actually going to scan them in and put them up there for you so you don't have the contract in front of you. So if I'm training live, I'm sitting here holding a piece of paper and you can't see it, we want to do it the right way, okay? I'm going to go through this pretty quick. I'm just going to kind of hit the blanks and things. I just touched a lot of it in some of the new adaptations of the new form, and I like a lot of those new forms. They clarified a lot of things. Some of it you wondered why it had to be clarified, but that just means that we kind of the dumbest among us, and so we kind of try to help them. So anyway, parties to the contract, the seller and the buyer. Now this, under no circumstances do we ever put to be decided, seller of record. Do your homework. Whatever it says in the taxes is what we have to put. I don't care if the other agent says, oh, well, blah, 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 blah. Well, why in the taxes? Well, they hadn't probated the will. Well, then it's still in his name. Why are you listing a property that the will hasn't been probated? Okay? You've got a property on the market that now I'm going to contract. It's not going to close on time because you didn't probate the will or something like that. So we go off the taxes, and if they're trying, why do you want it in Mr. Smith's name when Mr. Jones is on the tax rolls? Well, Mr. Jones died and Mr. Smith has possession of it. Under what grounds? What court? What's going on? Okay, so we use the tax records. We use the legal name for the buyers as to how they want this done. Do they want it in their LLC, their corporation? They want it Mr. and Miss, who they want. And this is where sometimes you'll talk to a lender because a lender may say, I only want the husband on the contract, or they only want the wife on the contract because their credit is good. And so you want to make sure you involve your lender in this. And we've got some very good ones out there that we can recommend. Once again, we don't take any money from anybody, and all you guys have favorites that help you quite a bit. Okay, lot, block, county, address, all that has not changed. So you want to fill those in to the best of your ability. And as with so much things, you want to take those off the tax rolls if you can. And they're woefully inaccurate. Pardon me. They're woefully inaccurate at times, but do your best to take it off the taxes. And we're not title company, we're not this, we're not that. Let the title company do their job. If those things need to be changed, then that's great. We don't want to get outside the scope of our responsibility because that's where we get in trouble for practicing law, and that's where we get in trouble for, E&O doesn't cover you if you do something that's not your responsibility as a real estate agent. So we want to make sure we get those, okay? We want to make sure that we review the improvements, the installed and built, permanently installed and built-in items is in bold on the contract. It's in bold, so this tells you things. We have had this last year, we've had cases where things have been taken down that shouldn't have been, and all kinds of stuff, cooking equipment, all of the property attached to all that's got to stay. Mounts and brackets for televisions and speakers and all of that all has to stay. Hang on just a second here. Okay. That all has to stay because we want to attach to those. We don't want holes in the wall and things like that. Accessories, related accessories, blinds, fireplace screens, curtains, window shades, draperies, mailbox keys, above ground pool, swimming pool equipment, maintenance, garage doors, garage door. It's sad that we have to list all this stuff, but all this stuff has to stay. And I've seen so many people take their fireplace screen. They're not allowed to. You're not even allowed to take fireplace logs. If you've got gas logs in there, and when it's being shown and contracted, it has to be there. Okay, and then we go down, any reservations for oil and gas or other minerals, there's a separate amendment to attach that, an addendum to attach to that, and we want that addressed as well, and we do get a lot of that in East Texas, so we want to make sure. Cash portion of the sales price, unbelievably that they had to add this. Cash portion of the sales price does not include proceeds from borrowing of any kind or selling other real property except as disclosed in this contract. It's real simple. You can borrow money and call it a cash down payment, okay? I thought I knew that. I'm surprised some people don't, okay? Leases, okay, residential leases, the property, you need to check if they're fixture leases, the property's leased and all that. Now, guys, here's a situation we get into a couple of times every year. If you've got an investor selling a house and the house is still leased for 5 months, 6 months, a year, whatever, the new owner has to honor that lease. You can't just throw the tenant out. Okay, so keep in mind, and you need, if you've got investors, and we have investors right now selling some property, doing something, we have investors buying some property as it's coming down, you want to make sure that the leases that you get copies of them and things are the way they should be, and you want to make sure that you advise, because we do have some buyer's agents out there, that the new owner cannot take possession of this house until, okay, the lease is expired. Okay. You're going to go in earnest money and termination option. I think they've done a real good job with that as well. Deliver within 3 days of the effective date. Of course, doesn't count weekends, doesn't count holidays. So you want to make sure of that. Option fee. And also, they've got a place in there if you want to deliver additional earnest money termination option. Now, remember, the termination option ends at 5 o'clock. Anything else is midnight. Termination options ends at 5 o'clock. You've got all kinds of agents emailing at 4:59 and 4:55. If you know that your buyer is going to terminate, do the right thing. I know that some agents don't do the right thing with you, and I'm sorry for that, but let's be better. Let's take the high ground. Let's do the right thing. And so, by the same token, I apologize if you have some very unscrupulous buyers out there that terminate at 4:45 with an email, because that's all it takes, or even a text. Okay, as long as you've got something in writing. Okay. Of course, failure to time to deliver the earnest money. The seller has remedies, can sue them. I mean, they put all these in here, which is really horrible. But failure to timely deliver the option fee. If you don't have an option period if you don't deliver the option fee. Okay. Title policy. Seller shall furnish the buyer, and you check which expense and you check which title company. Traditionally, the buyer chooses the title company. We do have some title companies that are owned by other agents, and they're going to send out, a lot of them send out a deal, or they put it in the documents in MLS. Here's what's needed to submit an offer. I'm sorry, TREC requires that you submit all offers. Okay, and we've got some that own a piece of a title company that says, must use this title company. No, we must not use that title company. If you own part of it, that's up to you. If we have the buyer, our buyer will make an informed choice based on the recommendations that we are capable of giving him, not based on what you make profit on. Okay, that's not up to you. And you can send us a list all day long of what it takes to make an offer. I'm sorry, TREC says you have to present all offers, and so you need to present that offer. If you have somebody, there is a form that says you need to be present when the offer is submitted. You can't talk. So if you got somebody being ugly with you, you just send over that form that says, I want to be present when this offer is submitted. And you're entitled to sit there and listen to them submit the offer. And that's all you're entitled to do. You're not allowed to comment or anything like that. Now, I'm going to tell you, if you do that, that makes it a contentious deal pretty quick. But it's already contentious if they're trying to tell you how to do it. I'm the one that pays the E&O. You pay it through me. Okay, we pay the E&O. We tell you how to fill out a contract. I don't want to be doing business with title companies that, we've had one that wrote us checks that wouldn't cash. We went to they had money. It was in another account. They just didn't get transferred. That's a hot check. Okay. And when I told the guy who wrote me a hot check, he got really mad. I'm like, well, it was a hot check. Well, I had money in another account. They just didn't transfer it over. I said, well, that's not my problem. The account you wrote me the check on. So you want to make sure that you give great advice on title companies, and you want to make sure that your buyer makes an informed decision. Okay, we don't want a conflict of interest. Do your best. Do what's good for your client. The ultimate goal is to get them a house, and that's what we want to do. Okay, title policy and survey. Okay, you're going to go down all that good stuff. Just went over that. Title commitment was in 20 days. Now here's for you guys in Longview. I apologize to you if you're in Longview. It's 20 days with an automatic 15-day extension. They don't have to tell anybody. They go up to 35 days. Longview is absolutely the worst at title commitments. Okay, we're lucky if we get one in 20 days. We're lucky if we get one in 25 days. In Tyler, in Dallas, in Houston, and even in most parts of West Texas, we get title commitments very, very quick. And Tyler, we get them in 72 hours or less, and we can close a cash deal. If you open it on Monday, we'll close it on Friday. In Longview, we have deals wait all the time because of the title company, because there's no competition over there, all right, that forces them to do business in a better way for you guys, okay? And I'm sorry about that, but trust me, there's people coming, all right, to that market that will get you the title commitment under a week. And then we can really do business. And some of you have met them. And I've just got to tell you, it's amazing when you get the right lender or the right title company on board. Okay? Survey, within so many days, the effective date of the contract, you want to finish a T40, you want to furnish a T47. And it says in bold on the contract now, if the seller fails to furnish the existing survey or affidavit within the time prescribed, buyer shall obtain a new survey at seller's expense no later than 3 days prior to closing date. Now, guys, this is non-negotiable. Okay? This happens to us all the time where, they go, well, it's only a day late. No, the contract says what the contract says. And I'm sorry if the seller doesn't get their job done or something like that doesn't happen. What you gotta have there. Now, we still run into this, okay? We'll have a buyer's agent say, well, you furnished the T47 in the survey, but it was wrong. Doesn't matter if it's wrong. That's addressed in here. If it's not acceptable, then you check who the seller or the buyer expensed up to 3 days prior to closing, okay? Boom, okay? You go on from there. But we've had buyers, agents, who have not been trained, and they're from the major franchises that claim to train, okay? Oh my God, well, it was wrong, so therefore you owe us a survey. Read the contract. We just had to furnish a T47, okay? And the existing contract, we did, okay? And we filled it out properly. And it says on here, buyer will, if it's not acceptable, buyer will pay. So we want to make sure that we got all that going on, okay? Then you got the other boxes within so many days of the effective date, buyer will obtain a new survey, and then you got so many, if the seller will obtain it, seller's expense, you get all that. Objections, some people put under objections, prohibit the following. Somebody put residential use. I don't care if you do. You don't have to put it. It's a residential contract. You don't have to put anything in there. You have some broker, you can't put that in. You can put, I'm telling you, you can put that in there. They don't tell you how to fill out a contract. I do, okay? Ashley does. Renee does. Linda does. My wife does, okay? So I don't care what anybody else says. Present the offer, okay? You're not telling us how to fill out a contract, how to prepare our paperwork, okay? So we want to make sure you can do whatever you need to in there. I usually leave that blank, but you can put residential there. I don't care. Okay. Then you got title policies and all kinds of other stuff that you go down. Tidewaters, annexation, property located in service area, utility district providers and things like that. Public improvement, transfer fees, propane gas system. Okay. I want to tell you one thing about propane. When you make an offer on the house, check the propane, get a reading on the propane. We've had, in the last 3 years, we've had 3 instances where buyers bought the property, and in 2 instances, the day they were moving in, somebody was pumping propane out of it because propane's expensive, and the old seller was taking their propane, and they were stopped right then. And in 1 instance, it had already been done. Okay, so they stole the propane out. So you want to make sure, get a reading, okay? You want to make sure that it all's done there, okay? And there's an addendum containing the notice approved by TREC required by our parties should be used if there's a propane issue. Water level fluctuation, don't worry about that. Access to property, this is a big deal. If you list a property, the seller is under contract responsible to keep all of the utilities on for the entire time of the contract, okay? And during reasonable hours, you can have inspections and things like that. Now, that doesn't mean your buyer can go every other day to measure for drapes and do this and that. You want to be very nice. You want to be very considerate about that. Get your stuff all at once, okay? We have had buyers that get just totally, they want to meet there with 19 contractors and this, that, and the other and all that. I'm sorry. Once you get it, your contractors can be there. All right, you're allowed inspections, you're allowed things like that, but let's be very careful and very reasonable. It says reasonable. It doesn't say unlimited, okay? Seller's disclosure, stuff like that. You got notice or you have so many days notice. That has not changed, and we're proud of you guys for that, okay? You can check the box for property as is. If you notice some defects, you can check buyer accepts property as is, providing the seller will do A. B, whatever. Your option period protects you and gives you some inspections, and they can back out during that. I know it's counterintuitive. The seller, when it says as is, the seller says, "Well, they bought it as is." Well, yeah, they can option out. You either fix these things or not. You're going to fix them for the next guy. Guys, we have had instances this year, not with our agents, but with agents at other places, where they tried to cover up things and they tried to hide defects. If you know something, disclose it. Okay? And here's the deal. If you know something and you disclose it and it wasn't under contract and it was repaired, you can say it was repaired. The homeowner wouldn't replace that 3 pieces of rotten wood, did this, did that, did that. So there are things. And if it needs a contractor, have a few contractors you refer them to so that it's done right in those type of things. We want to sell the best homes on the market, and we want your buyers to get the best homes on the market. I don't want, I don't want to hear from a seller, I don't want to hear from a buyer that a seller did something and one of the agents approved it. It happens, okay? But we want to make sure. Lender required repairs and treatments, okay? You got a situation there. If it's over 5% of the sales price, the buyer can terminate the contract and get their earnest money back. And that's at any time. That's at any time. Okay, you can be negotiating. So here's the deal. You got your option period. You went through, okay, or maybe your customer didn't take an option, and then they decided, okay, at the very end to do an inspection just for their own, and they found out this house, you got a $300,000 house, and they found this house had $40,000 worth of foundation repairs and this, that, and the other. Well, they can get their earnest money back and get out of the contract right there because it's not covered by the option period. And we have had one that did that this last year, and the other agent said it didn't apply. Well, the other agent got schooled pretty good by one of our agents, and I was very proud of them. And so it totaled over 5% of what they were asking for the price of the property. So the buyer got to back out. There's really not anything you can do about that. Completion upon repairs. Repairs have to be done before closing, okay? And here's the deal. Paragraph 15, under paragraph 15, you've got, remedies, you can sue them or whatever, or you can extend the closing date by up to 5 days for the seller to complete repairs. You don't need the seller's permission to do that. So let's say if you got to go out and do your walkthrough and the seller says, "Oh yeah, I'm going to get to that. We'll get to that this afternoon. Go ahead and close." No, we'll extend the closing 5 days. And the seller's going to twist, but you've had, okay, we've been under contract for 35 days. You had this after the inspection. You've had 25 days to do these repairs. You haven't done these repairs. I'm going to extend the contract for 5 days. You can automatically, without their permission, okay? Residential service contracts. Can't buy a decent one for under $500 nowadays, guys. If you're asking for the seller to pay for that, and those are coming back in play, sellers are having to pay more closing costs and things like that. Want to make sure that we get that done, okay? Broker and sales agent disclosure. If you're related or have more than 10% in it or whatever, you've got to declare it, okay? Closing, there's your closing date, which we know for lenders, sometimes an imaginary date, but not for us. And most of the lenders that we recommend seem to make these closing dates. So there's no reason for not to have the right closing date, okay? You get back around possession. It can either be closing and funding according to a temporary residential lease. Now, you got a consultant in bold letters says consult your insurance agent on the change of ownership or possession. I'm going to say this, and I cannot say it enough. If you do a temporary lease and you are a seller, pay the buyer. If you've got the buyer and the buyer is doing a temporary lease for the seller, insist on a deposit. We have had more cases this year where the seller moved out less to have the house filthy, damaged, and everything else, and temporary lease, they paid their $20 a day or $1 a day or whatever. You know, we tend to want to be nice and this, that, and the other. I'm sorry. You know, and we have other agents throw a fit. Oh my God, you're demanding a deposit. Well, then that indicates to me if you're throwing a fit, they intend to leave the house in a very poor condition. Okay? This house needs to be pristine and ready to move in, because what you've done is you've effectively deprived your buyer of a walkthrough by having a seller's temporary lease. So you want to be very, very careful of that. Okay? Buyers' temporary leases, don't be surprised. They ask for a deposit. They ask for this. Do whatever, but don't do a seller's temporary lease without some form of deposit to make sure the house is clean. You know, and if you're talking a $300,000 house, $300 or $400 deposit, okay, you can usually get the house clean for that if they left it filthy, okay? Special provisions, says right in here, okay, any information on the statement that completes a blank contract form discloses factual information provided. So that's, you know, real estate brokers and sales agents prohibit practice of law. This is where if the name's too long, you put it in here. The address is too long, you put it in there, that type of thing. Settlement and other expenses, seller has, it explains what those are and what you get. You can't use it to replace carpet. You can't use to do this. You can't use to do that. So settlement expenses are coming back in. There's some that wasn't. Prorations, it explains that. Everything's prorated from the time you buy. Now, I always tell, even though the title company tells them, they're going to be very, very excited when they're buying this thing. So what I'm going to do is I'm telling I'm going to remind my buyer, hey, look, you're going to get the total tax bill at the end of the year, but they've paid you up till this day. So you want to make sure those are, you know, of course, your prorations this time of year are pretty cheap if you got the seller. Anyway, but casualty and loss, we all know about that. If something happens to the property while it's under contract, buyer can back out, or if they rebuild it, they get approval, all that good stuff. Default, if the buyer or seller, either one, fails to comply with it, they default. They agree to go to mediation to start with. Attorney's fees, those type of things, buyer and seller, or broker or escrow agent, we're entitled to recover reasonable attorney's fees and all costs in any such proceeding. Claims escrow representations, federal tax requirements, okay, all of that. You're going to get over to the back. You got your notices to the buyer and seller. Do not put yourself as the person that everything comes to for your buyer or seller. Put their address, put their phone number, put their email, put everything in there for the title company to get. I know that we have some agents that have used it, or we've had buyers or sellers contact each other. And if we do, we deal with that through the legal or through TREC or through whatever we need to do. The reason that we put those on there is because if you're having everything come through you and you forget something, okay, you become liable. Your errors and omissions does not cover something you miss if you were supposed to disseminate that information. It's outside of our scope of responsibility. The title company needs to be able to communicate with these folks. Then you check all the forms you've assigned. If there's an attorney involved, bless your heart, you put their information down there, okay? Executed dates, all that come through. One of the things I do want to touch on, and when you get down here, you got another page, you got a receipt, but you get down here, all commission for agents, you can write anything you want here, but it says right in here, MLS offers of compensation trump. We've had a situation to where agents will write 3% in there when it paid 2.5%. It pays 2.5%. Doesn't matter what you write. This is an information. It says broker information right here. This is an information sheet. It is nothing more than an information sheet. And as such, okay, it's not a part of the contract. So when title company says, well, you know, we got this and it's supposed to pay. No, it's an information sheet. So I've had to school a title company on that. It doesn't matter what they write in here. It matters what the MLS says. And we have some agents. We had a Century 21 agent, okay, up in the North Country, threatened to scuttle a deal if she didn't get 3%. Her broker got her under control pretty quick, and that was sad, okay? She was, well, we just won't buy the deal. I'll just tell my people to go someplace else. I'll just take the deal off the table. I'm like, you don't have that right. She called me, and I said, you get your broker to call me because I deal broker to broker. Well, I knew her broker, so I gave him a call. Super nice guy. He said, Terry, I've got that under control. And he did. So you want to make sure you fill all that out. We will go more in depth with this. You got your receipts, receipt page and all that. We're going to go more in depth with this. I'm going to cover amendments. Amendments absolutely simplified up quite a bit this year. It's amazing what they do, and I'm going to have Carly put a copy of the amendment in this video for you guys to watch. This is a basic overview of where the new contract went. We hope that you enjoy it. We hope that we can bring you more videos like this, and we hope that everybody has a great year. And February 1st, I think these new simplified contracts are the way to go. They're absolutely helpful. And that traditionally happens when they bring out, last time they brought out a bunch of changes. When they bring out a bunch of changes, the lawyers write them for lawyers, and then us agents just tear them apart. And then they go, oh, we got to simplify this, we got to simplify that. So bless you guys. Please have a great year. If you need anything else, you let us know. More training coming at you. We're working on a studio so we can get everything for you. Please have a wonderful, wonderful year.